Thank you very much, Tamsin. Good morning, everybody. I'm very pleased to be able to present to you about the Massachusetts Wage Act, which has been and will continue to be a fertile ground for litigation, including a recent case that, to be totally candid, shocked a lot of us employment practitioners in April that I'm going to discuss. Um, Next slide, please. Um, the reason why the Wage Act is so powerful and is so fertile for litigation is because it offers a prevailing employee treble damages automatically plus attorney's fees and costs. This is done regardless of fault or intent, known as a strict liability statute. There's no, I didn't realize I was violating the Wage Act, or I was not aware that this is what the law is type of defense. Under the Wage Act, the president of the company, the treasurer of the company, and any officers or agents having management of such corporation are considered employees. That means they are potentially individually liable if a departing employee has concerns about whether a company is solvent or if it's in bankruptcy. Then the president, treasurer, and any of those officers or agents will likely be sued. And even if not, an aggressive plaintiff's lawyer could decide to sue them. And we're seeing in litigation the plaintiff's bar is trying to expand who's potentially liable, including passive directors potentially. And that type of litigation is winding its way through the court system currently. When terminating an employee, that employee must be paid in full all wages on the termination date. And that includes commissions that are due and payable, as well as vacation time or PTO. And finally, it's unlawful to retaliate against an employee who complains about an alleged failure to pay wages. And that's true regardless of whether or not the employee is correct or not in the employee's complaints about an alleged failure to pay wages. Next slide, please. As I said earlier, in April of 2022, a lot of us were very surprised by a decision by the Massachusetts Supreme Judicial Court. Over the last 20 years or so, there had been a common practice using a safe harbor period if there were errors involving a failure to pay wages, which would be available to an employee, or which would be available to an employer as long as an employee did not file a Wage Act complaint prior to receiving the wages owed. So for example, there's a payroll error with a recently departed employee and late payment occurs about a month later. The employer could then cure that by offering some interest payments as well. And then the employee would have no damages and would have no claim under the Wage Act. This was actually a practice that was developed under the Superior Court, our trial court level, with a decision that came out and then was consistently upheld at the trial court level. In April of 2022, however, the Mass Supreme Judicial Court overturned the legality of this practice. And in that case, it involved a failure to pay vacation time or the late payment of vacation time 3 weeks after termination. An employee was terminated after she was convicted of theft. So this was not a particularly sympathetic plaintiff, but nonetheless, the SJC found for her. It was undisputed the employer paid the employee vacation time 3 weeks after the termination date. And then after she said to them, you violated the Wage Act, they then offered her 3 weeks of interest. So she sued, and at that point in time, she had no damages. She'd been made whole by the employer. Nonetheless, the Supreme Judicial Court held that she was entitled to treble damages on the day after discharge when she had not been paid in full all wages owed. So this was really a seismic type of decision that reinforced how careful employers in Massachusetts need to be to make sure they're not violating the Wage Act, even inadvertently or even in a way that's very small, a day late, for example. Taking a next slide, please. Taking a step back and just to differentiate between what is a wage and what is not a wage. A wage includes base compensation, so salary or hourly rate, accrued vacation or PTO, and holiday pay, as well as commissions. Next slide, please. What is not a wage? Sick time, severance, and bonuses are not considered wages under the Wage Act. Now, having said that, I want to be clear about something. I don't want to leave the impression that they're not wages, so therefore there's no obligation to pay. There might be a contractual obligation to pay, but just the treble damages individual liability of the Wage Act will not apply here. Next slide, please. So I said that a commission is a wage and a bonus is not a wage. So the question you might have is, well, what's the difference? And it's often very hard to tell, and it's something that's frequently litigated in courts, where there's something that's referred to as a bonus, but a plaintiff or an employee will argue it's actually a commission subject to the Wage Act. So a commission under the statute is something that's definitely determined and due and payable. Definitely determined means arithmetically calculable. There's some sort of formula to arrive at the number. And due and payable means all contingencies for payment have been satisfied. So if a commission is due once the employer, the company, receives payment on an invoice, then that commission is due and payable to the employee. Commissions are also generally tied to individual performance. They're tied to the completion of a sale, closing of transaction, based on an individual meeting a criteria rather than a company-wide performance, and they're usually non-discretionary. A bonus, on the other hand, is based on a company-wide performance measure, so how a company is performing, a target bonus, or based on some sort of milestone, so sign-on bonus, annual bonus, retention bonus, and it generally, although not always, gives the employer some level of discretion. Now, one thing to note is just because something's called a bonus does not mean necessarily it is a bonus. Next slide, please. So how do you avoid these types of complaints, the dreaded Wage Act complaint? One of the most important ways to avoid the dreaded Wage Act complaint is to promulgate and enforce written policies. So vacation time, PTO, commission plans, make sure they're in writing, make sure they're distributed to employees, and make sure that employees have signed them confirming their receipt of them. Next slide, please. Before terminating an employee for misconduct, make sure you're ready to pay the employee all wages, including vacation/PTO, on the date of discharge. And the SJC, in the decision in April 2022, actually said, be ready to suspend employees before terminating them if you're not ready to do so. You want to make sure your managers are very well trained and aware of the Wage Act, and you're working with counsel, hopefully your friendly Davis-Malm attorneys, when dealing with severance agreements to make sure that the Wage Act is properly carved out. So thank you so much. And now I'd like to turn it over to my colleague Tamsin, who's going to talk.